So with regard to today's hearing, we are here to address a correction from the prior contempt related to child support. Ms. Baldwin's filed, and I believe distributed to you, Ms. Potter, a proposed new order related to that. And I understand that you may have some disagreement or some comments about that. So I'll hear from you first, Ms. Potter, if you have any concerns related to that proposed order.
Well, I just had a couple of questions just to make sure I'm understanding it correctly.
Sure.
So this proposed order is basically replacing what she was asking for before, correct? It's not in addition to?
Yes, it would replace or supplant, get rid of, change, and make the prior one basically non-existent, other than that's been amended and this new one would replace it.
Okay, so am I still being considered in contempt of court even though I had been paying the child support payment?
That would be the net effect of that order. Yes, it would still be a finding of contempt, showing a dollar amount that was owed for a period of time with interest, and then also having an opportunity to purge that contempt by making timely payments.
Okay, I guess I'm still kind of to why I'm even in contempt, because like I said, the documents that I have filed do show that the payments had been made except for that time that I was out for my surgery, which I was not receiving any payment from any source whatsoever. I wasn't getting medical leave or any sort of income during that year. And remember, you had even originally stated that you were going to be taking off the month of November and December of my back payment due to the information that I had filed with the courts for my surgery. Is that still going to be in place?
My understanding is we're only here essentially for presentation. The court at the last hearing, sort of the hearing before last, where she actually provided some of the documentation, and we were able to see that some payments had been made. But there was also large gaps in payments, hence there's an additional almost $4,000 of arrears. The court was pretty clear. I'm still finding you in contempt, based on payment during months where she wasn't in surgery, didn't have those issues. The only question that really was on for today was the total. And then the court said it would think about the fees and the sanction. And so I just left the fees and the sanction blank for Your Honor to fill in. And then filled in the updated amount, and then we provided that documentation as
well. So Ms. Potter, I recognize that there was a period of time where the surgery was ongoing, and there was recuperation from that surgery. The other amounts that the Division of Child Support records showed that you did make payments when we previously thought that you had not made payments. You did in fact make payments. So that reduces the contempt finding from roughly $8,000 down to just shy of $4,000. I'm sympathetic to the position you're in when somebody is undergoing surgery and recuperating from surgery and not having income. That makes it difficult to pay child support. And on the other hand, the other view of that is that the child's needs continue through that period of time, and then there's still a need for support during that time. So when I took a look at the numbers from the Division of Child Support paperwork, looks like you made a payment in August of $506. That left an amount owing of $314. September, October, November, and December, there was no payment during that time, and I understand that may be due in part to the surgery or illness. And then in January of 2023, there was a payment of $456. So when each of those are added up, I came up with a total of $3,963.96, which is slightly different than the $393.83 that was listed on the order. So I'm just going to make just that one small correction. As far as the civil penalty, it'll be at $100. And previously, the attorney fees previously were $1,450. I'm going to reduce that down to $500.
And Your Honor, could you say that top is 3,963?
Yes.
And then just make sure you fill in that same information on page 3 of 4.
So I guess my question with the total then is, I mean, I am not denying that I still owe for those months. But I guess where I'm at is when we had our hearing, I believe it was on February 14th. I remember you had stated that you were going to take off 1,740 from the owed amount for the months of November and December when I was out for my surgery. So I guess that's my question, is that still going to be deducted off of that 3,963 as you had said that it was going to be the case?
It's a good question. You said that was from the February hearing.
Yeah, I believe it was the February 14th hearing is when you had said that. I've got my notes written down everywhere here, but I believe that was the February 14th hearing. You had mentioned the $1,740 that you were willing to take off of the arrears for the months of November and December.
So just I'll share my thoughts from the meeting minutes and I'll hear from Ms. Baldwin. So the docket notes from that particular day talked about the contempt from January 24th, and that Ms. Potter had additional documentation showing payments were made during a period of time. And so then the court verified that Ms. Baldwin's client did receive payments from September of 21 to August of 22. And that there were payments from September of 22 to December of 22 that were not paid. And then there was discussions about medical documents and wage garnishments and some payments being made in January and February. This is coming from Ms. Potter. And then the court indicated that there were issues of arrears, about $200 a month, arrears and interest that needs to be adjusted because of those earlier documents that were not known, and the attorney fees need to be adjusted. So there, I very well may have said something of that sort during that particular hearing. At least in my mind and based on the notes here, that wasn't something that any adjustment for November and December wasn't specifically noted or wasn't necessarily a highlight. So there was the notes that indicated that the payments from September of 22 to December of 22 were not made. And, I wouldn't put it past me, it's kind of just a general sympathetic, compassionate response to somebody who's not working, that I may have made that offhand comment. But I don't think that was kind of the main gist of my comments on that day. And certainly there's different lenses in which people receive information. So that's kind of my general thoughts. I'll hear from Ms. Baldwin, then we'll hear from Ms. Potter.
So that was my understanding, is the court wasn't holding her in contempt for November, December, but you were still finding the judgment, that you were essentially holding her in contempt for the failures to pay for August, September, October, which were the up through essentially when she would have been in surgery. So that was my understanding, but that the judgment would stay in place.
I did make a payment in August. It was September, October, November, December. September, I received a letter from DCS, which I filed with the court saying they were going to start garnishing my wages, which is why I didn't make that payment in September. And then October, November, December, until January 4th, I was out for surgery and healing, which I also provided the work release letter and the note from my employer and the doctor as well.
Yeah, I don't have any quibbles with the fact that you took time off to heal from the surgery, not at all. There was a period of time where the payments were not received. I recognize that there's hardship when a person is not working and that there's causes of arrearages and the like. So the contempt finding basically indicates that there was not. Basically, it's somewhat open or more broad. It says the support orders were not obeyed by which was signed on February 4th of 2021 and July of 2022, and it didn't receive the monthly support payments. It doesn't go into the specifics of which month or which period of time. So
Okay.
because there was at least 1 month during that period of time that was not paid on a timely fashion or was not paid, then I feel comfortable with the contempt finding and still, and then just taking into account the judgments of the monies that we're due and owing will be represented in that amended contempt hearing order.
I also received a letter from basically the Department of Revenue, and he will be receiving my tax return as well. And if he has not already,
Okay.
he's getting my full tax return. So that will be taking care of a lot of that arrears amount. So I guess my question is once this arrears amount is caught up, am I still having to pay that additional, $200 on top of my monthly payment?
It's a great question. The contempt order, this amended contempt order indicates that just making payments for 6 months on time, just the regular payments.
Okay.
And then paying $200 per month towards the arrearages for a period of 6 months, that will purge the contempt and basically say that you've satisfied it and it goes away.
Okay, so I guess what if I wind up getting that arrears paid off before that 6 month period of time, I guess is my question.
My
It's not
sense, go
yeah.
ahead.
She's
Nicole.
not obligated. Once the arrearage is paid, it's paid. So the $200 is only attached to the arrears. Once they're paid, you're just obligated to continue to pay your regular child support.
Okay.
And the order does reflect that. It says once it's the arrearages has been paid off, then you don't need to pay any extra for the arrearages because they have been satisfied.
Okay.
Okay. All right. So I've signed off on that order. I appreciate everybody's assistance and help. So that'll conclude that case for today. Pedersen, and Mr. Fuel is representing Mr. Thomas Pedersen. And Ms. Height is the guardian ad litem. She's present. We have Mr. Pedersen present and Ms. Pedersen present. Welcome and good morning to all. We are on today for a presentation of a temporary parenting plan that was prepared by Ms. Baldwin. I'll just double check with the parties, see if you have any objections or concerns related to that parenting plan. Mr. Fuel?
Yeah, Your Honor, I do have about a handful that we'd like to go through with the court.
Okay, go ahead.
So, well, we do have local rules. They do require compliance. My concern is that he submitted a fairly lengthy list to me only on Friday via email. And Your Honor certainly doesn't have those before you. We have local rules for a reason. And it's important that we all engage in those rules. Gives me an opportunity to review them timely. If they're ones I agree with, make those changes. And if not, be prepared to be able to point out to Your Honor the record where you said X or Y. And so that's my concern, is that in this case, Mr. Fuel hasn't abided by our rules.
Okay. We were here last, I think, was it on the 21st of March? I think that was our last hearing date. And so we set it to today's date. So theoretically, that should have given everybody enough time to get the proposed order out and then submit objections and submit those to the court for review. I did review the order on its face, and I have a few items, and why don't I just review those, and that may address some of the issues that Mr. Fuel might have raised or Ms. Height may have raised. So let's just take a look on page 2 of the proposed plan under paragraph 4 on line 9, where it says 12 hours. I ruled that it should be 8 hours. So I'm just going to make that correction instead of 12, and I'll put in 8. And then on the next page, on page 3, which is the paragraph starting on line 3, where it says the petitioner is authorized to make all standard health care appointments such as standard immunizations, well child checks, dental cleanings, basic care. The other party will be informed of any care that rises above this level. I ruled differently than that. I indicated that the mother would need to provide notice to the father of any routine or standard appointments or health care that was delivered. So that paragraph needs to be altered to reflect that. Page 10, this is under paragraph 13, under paragraph K1, where it says, I just had a question about meaning of this. It says on the second sentence of paragraph K1, says it's regarding hair follicle or urinalysis. says the request should be made in writing, by text message, or over the phone. I just didn't understand the language of or over the phone, what that was intended to be.
Just in the sense that you're using your phone to receive text messages. Your phone is where our family wizard is kept.
Gotcha. I was going to just remove that simply
fine.
because it talks about in writing. So I was just going to remove that to remove any ambiguity of the idea that it might be like a voice communication.
That's fine.
And then under 13K5, there it says, if a drug test shows positive for alcohol use, then that party's visitation shall be immediately suspended until further order of the court. My concern with that one is that I think it needs to be amended to say something along the lines that says, if a drug test shows positive for alcohol use within 8 hours or during respondent's residential time, then the visitation shall immediately be suspended until further order of the court. Because the way it reads now, that a drug test could be had on a Monday and it shows alcohol for a Monday, and then there's no visit until, maybe there's not going to be a Wednesday midweek, and there wouldn't be a visit until like the following. So there doesn't really impact the parent's ability to parent during the residential time. And that was really the court's concern, was focusing on having a clear focus and clear mind during and before and during the time with the child. So under that 13K5, I was going to add that language after the word or phrase alcohol use, then include within 8 hours or during respondent's residential time. And that also applies to the K3 up above, where it indicates the test must be prepaid. Should the test show positive drug or alcohol use, then the party testing positive must reimburse the party who requested the test. I think it should be limited to testing positive within 8 hours of or during respondent's residential time. So I don't know if that addressed any of the issues that Mr. Fuel that you had.
Oh, well, all of those were on my list. There are a handful of things which don't match what the court ordered, but I suppose I'll leave it up to the court whether or not the court wants to hear that or not.
I think as a general rule, it's best for me to know what your objections are in writing. That way I can review them, think about them, review my notes, not necessarily on the fly, and then make the adjustments usually before even the docket starts, and then tell you where I'm at with that. If I need clarification, I would ask the parties for clarification.
Understood, Your Honor. Well, then I'd ask for an opportunity to file those with the court. I appreciate the fact that you've got rules, but again, there are a handful of things that don't reflect what the court ordered. So it's probably better to be accurate than fast.
Sure.
And then I have no objection other than fees. I'm here today. We had an opportunity to do this already. My client's here today. So I'd ask the court reserve on fees and address fees at the next hearing.
We can do that. We can reserve on fees. I'm not inclined to grant fees, but we can certainly reserve it and hear argument from the
That's fine.
parties.
Will do. Thank you, Your Honor.
Ms. Height, does that work for you? I think you said yes.
You read my lips. Yes, thank you,
Okay.
Your Honor.
All right, very good. That sounds great. So we'll set over 1 week to the 18th for finalization of that parenting plan. Mr. Waters, and you're
Thank you.
here present. Okay, great. And then Anna Waters Rosencrantz, are you present today? Anna Waters Rosencrantz. If you're here, please unmute and state your name. Ms. Petrie, have you had any communication with Ms. Rosencrantz today?
I have not, Your Honor. No, I have not. Can you hear me okay?
Yes, yes.
Okay.
I can. Thank you.
Just making sure. I'm actually a little shocked. Maybe check the waiting room one more time before,
Yeah, thank you.
because it is her motion. So and she did show up for the last time.
Yeah, it is her motion. She sent out the docket notice and the like and filed everything. So yeah, I'm not showing, all I show is myself, the courtroom, your Ms. Petrie, Mr. Zandy, Ms. Miller, and a paralegal from Heritage Family Law.
Right. She also did not file a reply declaration.
Yeah, and had she traditionally done that? I mean, the case isn't terribly old.
No, it's not old at all.
Yes.
No, she filed her motion on her own. She may not have known to file a reply, but I think our response might have been a little intimidating.
Yeah. Yeah, so I'm not sure.
So I guess I would just move to dismiss the motion.
Yeah, I mean, what we could do is that we could simply strike it from today's docket. That kind of leaves it pending without resolution.
Yeah, I would actually just request a dismissal of the motion or denial and dismissal.
Would you be willing to wait until the end of the docket before we make a determination on that?
Sure,
Okay.
not a problem.
Let's do that. I feel a little more.
I have to stick around and wait for Mr. Zandy anyway, so not a big deal.
Right. And I think
Oh, there he is.
he was able to log on. Great.
I've got, and I apologize, I've got two hearings on. I've got the big screen in Wahkiakum County, but they're taking a while, so I thought I would sneak over here. So I apologize and appreciate your kindness and patience, Ms. Petrie.
Oh, no problem.
All right, so we're here in the park. Andy's representing Dennis Park. Ms. Petrie is representing Melissa Park. This is on for Ms. Park's motion for spousal maintenance. I've reviewed the pleadings, the CR2A, the declarations that were filed by the parties. So I'm ready to go. So I'll hear from Ms. Petrie.
Thank you, Your Honor. Your Honor, this is a case where it's a 47-year marriage. So that is definitely a long-term marriage where my client should have filed a motion for spousal support at the beginning, but she did not for whatever reason. So as soon as I came on the case and realized the error, I went ahead and filed the motion because she definitely does need some support. With regard to the financial situation of the parties, we have met in a settlement conference and we were able to resolve the property division. So the spousal support issue is the only remaining issue. And my client is seeking spousal support and she is seeking long-term spousal support. My client's financial declaration outlines that her retirement income is and disability and everything else that she has comes to about just under $5,000 a month, around $4,500. Whereas Mr. is still working. Yes, he is retiring this month. However, his normal income is around $9,000. During the marriage, this 47-year marriage, my client's the one that set up their retirement investment accounts. She made sure that upon his retirement, his income would not diminish. What they've produced to us and to the court is simply a Social Security statement of what Mr. Park will end up receiving from Social Security upon retirement. But just because he's retiring doesn't mean he's not going to go into private practice. It doesn't mean he won't be consulting and be receiving consulting income. And my client set him up so that his income would not be impacted deeply. She did a great job on their investments. They had quite a sizable estate to divide. And they've both received, an equal portion, an equitable portion of the estate. However, husband's actually receiving more of the investments, more of the cash, and more of the retirement, whereas my client took property. Excuse me. So they both have retirement accounts, but his is actually sizably larger. The roommates that they brought up that my client has are not paying rent. One is not working. He is disabled. And the other one is one of their adult children. And that's pretty normal that adult children come in and out of mom and dad's home as they navigate their way through life.
Can I ask a question? Are the roommates, is one I understood was Mr. Park's brother and another was the niece of one of the two parties?
Yes, I think so. But it's a family member.
Family, okay.
They're all family. They're both family members, but neither of them is paying rent. And, oh, I'm sorry. The niece has actually been gone for a year. I just got a notification. Anyway, he still will be receiving or making and having income of about $9,000 a month, where her max is going to be $5,000 a month. This is a long-term marriage, and under the law of the state of Washington, the equalization of the household incomes is required by the court. which we calculate out to be a $2,000 a month spousal support award, and that would satisfy the statutes and equalize the income.
All right, thank you, Ms. Petrie. Mr. Zandy?
And thank you, Your Honor. I do represent the original petitioner in this matter, Dennis Park. And I think the good news is that we were able in the middle of last month, excuse me, to resolve this case via the CR2A agreement. So I think first and foremost, that's beneficial to both parties. I think it's also beneficial to both parties that after a 46-year marriage, they both are now in a position to retire. My client details for you that he's now 70 years old as of April 8th. As of yesterday, he was officially retired. This is not news to anybody. This was always the plan. The fact that he did work till the age of 70, again, I think is indicative of his work ethic and the fact that he's always been a very good provider. Ms. Park also was self-sufficient while she worked. She was able to take an early retirement due to the investments, due to the fact that the finances were in good shape for both of them, and that's where we're at. If we look at the CR2A specifically, and again, I would certainly submit that maintenance is not an absolute right under the statute. Now, you look at one party's need versus the other party's ability to pay, and I have looked at this in a variety of ways, and I just simply cannot see a need of Ms. Park. My client arguably has an ability to pay. But when you look at the CR2A, we're starting now to get into very specific and I think very clear double dip requests made by Ms. Park in her ask of this court for spousal maintenance. If you look at what has happened, my client does detail for you that he was a long-term employee of Kaiser under the chemical dependency counseling sector of that facility. He spent a long time there. Again, Ms. Park during the marriage was well employed until she took the early retirement. That is what it is. Again, I think that's largely undisputed. If you look moving forward, my client details for you that yes, he retired at the age of 70, retired at the end of this divorce. Everybody knew that. That was disclosed through discovery at the onset of this case about 2 years ago. There was never a request for spousal maintenance because we would argue this is not a spousal maintenance case. Both parties are able to meet his and her respective needs. And I think that's been borne out, again, not only through the submissions and the financial declarations that were filed on each party's behalf, but again, it's contemplated in that CR2A agreement. If you look specifically at where we're at in this case, again, RCW 2609090 dictates that. I have printed out and reviewed a fresh copy of that, as has my client. And the statute specifically contemplates that need versus ability to pay. Also has the factors of the age and financial obligations of the spouse or domestic partner seeking maintenance, and from the spouse who maintenance is being sought, his or her abilities to meet his or her budget. So I think that's kind of where the crux of this case kind of lies in the arguments today. And again, that's borne out largely in my client's declaration. If you look at the CR2A, that gives you some very direct evidence as to what the need versus the ability to pay is. I think it's clear to see that Ms. Park is receiving not only the real property, which again is in a very desirable area with significant equities in Woodland. She's getting and being awarded the home that's roughly $695,000 at the $700,000 home with a remaining mortgage of less than $45,000. Her mortgage payment every month is only $1,800, a little bit north of that. I believe it's $1,834. And again, as Ms. Petrie references, she has at least one adult roommate. And whether that person is on Social Security or working or not, the fact remains that person is arguably or should be contributing to the household, whether that's through rents, whether that's through utilities, whether that's through anything else. That's a source of income, and that's a source that Ms. Park can rely upon. As early as a year ago, if we take her at her word in her declaration, she had a registered nurse living in the home, whether that person was family or not. Registered nurses, as Ms. Park is aware, because I believe she was one, make significant income. Arguably, that person could have been and should have been and presumably was paying some kind of rents as well. So while Ms. Park has the advantage of living in the family home with very little remaining mortgage, My client now at the age of 70 is forced to go out, secure his own mortgage, secure and pay for his own utilities and expenses, and essentially start over from scratch again at the age of 70. The only asset he has to do that is the retirement. That was what was awarded to him through the Vanguard and through the Kaiser retirement funds that we referenced in the CR2A and as referenced in my client's declaration. Hopefully, as is typically the goal with retirement, you want to preserve that cash account as long as you possibly can. He knows that he's going to have to secure that mortgage. He's going to have to secure his living arrangements with that. So that's a large question mark and a large unknown. That puts him at a distinct disadvantage. So while she's
question,
sure.
when you're talking about the pension, the cash account, I looked for and I didn't find, and maybe you know, or Ms. Petrie knows what that cash account, that Vanguard account is worth, what his retirement savings are worth, because I don't know.
The Vanguard cash account is a little over $800,000.
And I don't think that's accurate. I think that was an earlier date. And again, that's subject to the gains and losses. And my client's gotten hammered on that since the date of separation. We use for purposes of the CR2A, the balances of everything at the date of separation. So I don't believe that's accurate. I think both combined, the pension and the cash account might be close to that amount, if not a little bit more. But I don't think that's just one of the accounts. I had the pension about 250. I had the other at about, currently it's less than 600,000. It was about 630 at the date of separation.
In the cash account, when you say cash account, that means mutual funds or
it's a Fidelity account. So it's similar to a 401k or an IRA.
It's an investment account.
So it's not it's not a cash, it's not strictly cash. It's not a, okay.
No, he does not have cash sitting out there.
But it can be liquidated.
Sure.
It can, but it's subject then, of course, to the taxes and such of taking that out.
Income, right?
Yes, and the market fluctuations, which again has been a killer for I think everybody the last couple of years on those. So that's kind of where he's at on that. To the double dipping argument, if we were to assume that that's part of his income, again, it's part of the balance sheet. It's part of the CR2A agreement. So she's now taking away from what he has on the property side. In the same way, if he said, well, that's fine, I want to live in the family home rent free because my name was still on the mortgage. Again, that's inappropriate. I think that gets to the double dip and the crux kind of this argument. If you're taking from something that's been awarded to him as property, it's, I think, contrary to statute to then come back and claim, well, that's income to him. So we want part of that stream of income, which has already been awarded as the property side. That's the issue with this. If you whittle it down to Social Security, and again, I would certainly assume that the age of 70 is an appropriate retirement age. And typically we see 64 or 65. My clients surpass that to a large extent. I don't know where this allegation of he's going to go into private practice comes from, outside of the hearsay contained in Ms. Park's reply declaration. My client is bewildered by that. He says that's just not even possible or practical at this point. I've worked my adult life. I'm retired. I'm done. The divorce is about done, and I want to go on my merry way because life's too short to be dealing with these types of issues. So that's where he's at. So I can tell the court that he has no intentions of going in private practice. And again, even if he were, 70 is an appropriate retirement age. If we look at some of the other cash that the wife has, in addition to a home with equity of $650,000, she's getting significant other assets. She's getting roughly $407,000 in her own investment accounts. If you look at that CR2A, you'll see many references to the Lincoln financials. You'll see the Lafayette Life IRA, John Hancock. All of those together are $407,843. Again, that's subject to market change. We realize that in the same way that my clients' investment accounts are, but that's a source of income she has. She has her Social Security and her Kaiser retirement. Her Social Security and her retirement, again, as counsel states, is close to $4,500 per month. My client's Social Security is going to be $3,547, and we've provided you with the statement related to that, confirming that. If you look at the two sources and you compare apples to apples with this, she's actually making more money than he is. That's not including the fact that she's living in the family home. That's not including the fact that she's got access to potential renters and all these additional sources and stream of incomes. Both parties have the ability, and it's part of that CR2A, to generate $25,000 to $40,000 in cash apiece by selling the motorcycles, the bicycles, and some of this miscellaneous personal property that neither party really wanted to haggle with. I think that will free up significant funds. But at the end of the day, again, these parties are extremely close and in very close proximity to one another on the incomes. My client states that this $9,000 a month, even while he was working, was grossly embellished and not accurate. We've given you information from Kaiser, which shows his traditional earnings. Typically, while he was working, he earned between $2,300 and $3,700 net per month. That puts him at about $6,000. Again, a far cry from the $9,000 plus that she has alleged he makes. And again, that's while he was working. Now that source of funds is now gone, unless he chooses to draw upon one of those investment accounts. And again, time will tell us. He's only been retired for less than one full day as of the time of this hearing. That's kind of where we're at with things. I would certainly argue, and I think it's clear from the statute that this is not a case where we should, number one, double dip, and that the request based on that alone is inappropriate and based on the terms of that CR2A agreement. And even if this is a case where you throw out the property, you still have two parties who are in very equal parity with one another on their actual income. The difference is Mrs. has the ability to live in a very nice family home with very significant equity with adult roommates, as she's shown from time to time, and they can help with the costs and offset of that. She also has no debt outside of that mortgage, and that mortgage is going to go away very shortly. That mortgage is only $1,800 per month. My client can't secure rent right now for $1,800 a month, let alone a new mortgage with the current rates, which puts him at a distinct disadvantage when it comes to that. He needs to use what he has under the CR2A, property that was awarded to him, and to put down and kind of reestablish himself again at the age of 70. That's a financial hardship, and he realizes that, and he took that on with the terms of that CR2A. But he also has the uncertainty of what the market's going to do over time, and again, that's concerning to him. Now, we would argue that the double dip prevents the court from considering any incomes. The fact that he's 70 years old and has retired, again, I think is logical and reasonable given the circumstances, and the fact that the Social Securities are very close to one another. The actual incomes are very close to one another. Both these parties are retired. Again, this is not a case that warrants spousal support, and frankly doesn't comply with the statute or the case law. Like, we're asking you to deny that motion and that request, and essentially let these parties kind of move on with life, get reestablished. I think I think my client needs to get to that point and just deny the motion based on the arguments raised in my client's responsive pleadings. Thank you.
Your Honor, first off, she didn't get to retire early because she was fun or because she wanted to. She had to retire early because of her health, and she is now physically disabled due to health issues. Support, and we're not double dipping here. The assets have been divided. They are wealth-wise on equal footing, and that's appropriate, and that's fine. What we're talking about as far as maintenance is maintenance coming from ongoing income. That needs to be shared. This is a long-term marriage. Her health prohibits her from working ever again. Whereas he's in great health, and as counsel stated accurately, he has an amazing work ethic. He's the kind of guy that just can't stop working. That was one of the issues. So the idea that he's just gonna, boom, yesterday, stop working entirely, that's just not true. He always talked about going into private practice and doing consulting, especially with a large corporation like Kaiser. You know, he can make a lot of money that way. But he is debt-free. He's the one that has no payments. Yes, she has a small mortgage, but she still has a house payment. She also has a car payment that she still has to pay. Because of the fact that she hasn't been receiving, she's had to dip into credit cards. She has separate property debt now incurred after the date of separation because all those months went by when she wasn't receiving any kind of temporary maintenance.
Well, Your Honor, I just object to anything that's outside the scope of the pleadings. I don't recall reading that or seeing any information provided that. This is all new to me.
The objections noted, I do recall reading information about $28,000 in credit card debt.
Yes. Her roommate has no income, and she cannot work due to physical limitations, and she'll never be able to work again. So her income is set. He still has resources, he still has the ability, and he has the drive and motivation to continue working. So for him to say that, oh no, this is it, I'm not going anywhere else, or I'm not going to make any more money, that's just not the case. So we would object to his position on that, and calling this double dipping is misleading. Again, we have no problem with him retiring. It's true. They both need to retire. They are at that age, but his income is going to continue to grow where hers is not. And she's dipping into those investment and principal accounts in order to support herself. That's not going to last forever. She needs to have something else coming in. And as far as his income, it was $9,000 a month gross. He was dumping so much money into retirement and 401k that's what caused such a low net. But his income was up there, and our numbers are legitimate, Your Honor. We are asking that the incomes going forward be divided equally, $2,000 a month, temporary support when we get to trial, or if he needs to come back to modify, if he has evidence that his income, what his income is, that'd be great. But we are asking for temporary orders today.
Thank you, Ms. Patrick. Could I ask one clarifying question? I had a question about housing costs on your client's financial declaration. Indicated that the mortgage was $2,400 a month with $580 of property tax and $1,122 of insurance and what like. So bringing the housing cost to like in excess of $4,100. I was a bit confused by the $1,122 of insurance related to the house.
I'd have to look at that. Let me pull something up on that to see if I can figure that out.
Because I think the mortgage is about $1,800 a month currently.
1834, and I think that's all inclusive of the taxes and the insurance, Judge. They've been in this house for quite a while.
They have.
Yeah, and that would comport with a kind of a monthly payment, taken out on a mortgage a couple decades plus ago. So that's why I was kind of surprised by the housing cost being in excess of $4,100.
I'm looking at just 1 second. Your Honor, I can't figure out what that is exactly from. Those are the numbers that we were provided.
Okay. All right. Well, thanks for double checking and looking at that.
Mm-hmm.
All right. So here looking at 2609090, that's a great place to start since that's what controls the maintenance question. The court is to find something that is just and taking into account all relevant factors. And it gives some factors that the court is to consider, but that's not all. So we take a look at Ms. Park's financial resources, separate property that she's received, community property that she's received. Obviously, that encompasses the CR2A, which, by the way, congratulations to both parties. That's a pretty massive CR2A to take care of. And so that speaks well of both clients also. Also, we're taking a look at Ms. Park's ability to meet her needs independently. I don't think the time to acquire education and training to find employment is applicable. The standard of living, I think, is applicable. I don't have a lot, but I have a glimmer of what that, a glimpse of what that standard of living was. The home is it's not like a super expensive home, but it's above average in value. It sounds like there was a number of vehicles and motorcycles, and the parties are driving fairly nice cars, newer cars. So the standard of living seems to be higher than average. It's obviously a very long-term marriage. The indication is Ms. Parks is not in a position to continue working and that she has a financial obligation of a mortgage. And then we take a look, of course, of Mr. Parks' ability to meet his financial obligations and needs while possibly paying for and helping meet the needs of a former spouse. So when I look at all this, the CR2A tells me that there was an effort in that CR2A, the party to have an equitable division of the properties and the debts that the parties had. And while it's not a perfect 50-50 split because it's difficult to achieve that, there's some parity there that exists. At least that was my feel from looking at the balance sheet on that. Now we're looking at roughly the income flows that the parties have. it looks like, Mr. Park did make a good monthly wage in gross, and that he was bringing home a net of roughly $6,800 a month, and Ms. Park is bringing home a monthly income of roughly $4,200. So that's roughly a difference of about $1,300. Both parties currently have housing costs. Mr. Park will have housing costs. Ms. Park will have housing costs for probably another 18-ish months until that $40,000 mortgage is satisfied. So I think taking into account the long-term nature of the marriage, the separate property, the community property that's previously been divided, the ability to meet their needs, the standard of living that they had, the physical condition of Ms. Park, and Mr. Park's ability to meet his needs and pay for Ms. Park's needs. I'm going to order $1,300 a month of spousal maintenance for a period of 18 months. At that point in time, the mortgage will be paid off or soon thereafter or soon before. And that puts then she no longer has that housing cost. Mr. Park will continue to have a housing cost. So that brings down, so he will continue to have that payment. So I think that's an equalization, at least in my mind. So that's why I'm decided upon $1,300 per month for 18 months. And with the motion was filed on maybe Ms. Petrie, you can tell me when it was filed. So I'm looking at effective date.
Beginning of March, I believe, Judge. Does that sound right, counsel?
Yes.
All right, so effective date will be April 1.
Any consideration, Judge, for, excuse me, allergies are rough this week. Any consideration for the adult roommate that's currently residing with Ms. Park?
Yeah, I thought about that. Initially I thought, well, gosh, two able-bodied folks, why isn't there some rental? But then I learned a little more. One was a niece who sounds like may be in a position to pay some rent. And then the other person who's a brother of Mr. Park, who sounds like he's probably still there. Sounds like the niece possibly has moved out. From the brief description I heard about the brother-in-law to Ms. Park is that he's not necessarily has a lot of particular skills, just because it sounds like he may have been incarcerated for a period of time. And so whether he's able to pay rent or not is not a huge consideration. It sounds like there was an obligation to family, and sometimes families don't charge. And so kind of that social safekeeping and net that I think is in place. And so I take it into consideration, but don't find it determinative.
And I understand that, and that's certainly reasonable. I just wanted to just kind of put on the record, my client did have response to that, and he worked at Frito-Lay. There was a response, and
Right.
we got a lot of that information in reply, which kind of hamstrings us a little bit in the arguments for today. But I just wanted to clarify that. Thank you.
Good. Thanks for the clarification. As far as the presentation, would the parties be okay if we set it for 2 weeks? If the parties come to an agreement and get that order signed to us, we can strike it from the docket?
I don't think there's any dockets on April 25th, Judge. I think that's judicial conferences. Might need to go a week after that. But this should be a pretty simple order. Maybe even next week we can note it on, and Ms. Petrie and I can probably hammer that out in the next couple of days.
Okay, let's set it for the 18th. Thanks for that reminder of the conference.
Thank you. We're lawyers.
Yeah, that's a recommendation. The judge,
Mhm.
maybe if the judge and the attorney general have come to an agreement, that might not happen if they've agreed. But if they haven't, then it'll be in the boys' benefit.
Well, they're gonna get it to the point where they come and take the boys. That's, if you try to predict what the government's gonna do.
Mhm. Well, that's what we're trying to do, is to basically give them to the government so that the Rogers can be their foster parents. That's
And Ms. Winkles, I think that Commissioner Carmi talked to you about being appointed in that case.
Yes, Your Honor, and I've agreed to accept appointment.
All right, I don't know that I've seen the order appointing you. And if that hasn't been done, I'll take care of that today.
And I've agreed to be appointed for the children, just so the court's aware.
Right.
Okay.
Your Honor, I just got a text message right before hearing that she wants someone else to be her guardian, and encouraging her to be online. That didn't happen. Lots of moving pieces with this one.
That's
so
what I
it's not-
gathered from Ms. Carmi. So there's somebody named Nicholas Hupsky involved.
Someone else now.
And
as
Ms.
of this morning.
Ms. Fisher is wanting him to be the guardian, is that right?
Not as of this morning. Someone
Oh, okay.
else.
Who is she asking for? now?
I don't know the person's name.
Okay,
It's her
And-
boyfriend's mom.
In that case, I'd ask to set this over a week so I can speak to her.
okay, Ms. Coolwine, are you here?
Yes, Your Honor. Oh, sorry. I can start the video.
There you go.
Sorry.
Is Ms. Fisher, Angel Fisher, with you right now?
No, I'm at work. I think she's at Nicholas Husky's house. She was at my house over the weekend, but she left Monday morning.
Okay,
As of right now, she is no longer at his home. He just told me that she left.
He said he
This
sent me also saying that she left just a few minutes ago. And that so he's not gonna pursue it anymore, I guess.
Yes.
who was speaking there?
Rose, do you not see
Oh,
me?
Rose Hogan Nickel, okay.
Yeah.
For Rose Hogan Nickel and Ms. Coolwine, are you still pursuing guardianship at this point?
Yes,
Okay,
we're trying, Your Honor.
all right. I think Ms. Winkle's request makes sense at this point. There are a lot of moving pieces and somehow that needs to get sorted out. I think appointing Ms. Winkle's the attorney for Ms. Fisher is actually a very good idea to try to sort all of that out. So I'll put this over 1 week, and that may not be enough to get a direction, but I think we keep track of this case fairly regularly until we know which direction we're going.
And Your Honor, if I can make a request of everybody appearing in this case, if you have any contact with the child, if you can give the child my phone number, which is 360. If you can have her call me back as soon as possible so that I can set up to actually meet with her, that'd be great.
Okay.
1352.
What did I say? It's 3692.
Thank you.
All right, let me figure out the date here. So we'll be back on April 18th. Ms. Baldwin is here at
Yes, thank you.
10:30. Along with, I believe, Ms. Day has been appointed. So the current guardian wants to be relieved of their duty. And I appointed Ms. Day to look into this to find out if there was a successor available. And if not, whether we needed to have a dependency hearing. The state indicated they could not initiate that on their own, but I think they indicated a guardian could if that were necessary. But
Yes, Your Honor.
okay, so Ms. Day, I think I need to hear from you to see whether you're in a position to advise the court on this matter or whether we need more time.
Yes, so I have been able to reach out to many of the parties, meet with the children, et cetera. It does appear that the guardians are unable to continue to care for these children and they do wish to terminate the non-parental minor guardianship.
Right.
I was not able to locate a successor. And as such, I filed a dependency petition on behalf of the children last week. I can provide those cause numbers. And I reached out yesterday to see about arranging for service with Ms. Baldwin and the Attorney General's office, but I had not heard back. So maybe Ms. Olmsted can let me know if I can provide that by email. That matter has been filed. It is set for hearing on the May 8th at 9 a.m.
And I can just relate that we've received those documents. They look appropriate. And we'll be appearing on May 8th. Given that the dependency has been filed at this point, although we don't have any plans to move the children until the dependency court dictates as such, I would ask that the court in this matter enter the dismissal of the case, allowing my clients to legally be relieved of duty.
Ms. Olmsted, any comment?
Your Honor, I would ask for the case number. I haven't received those documents, the petition that Ms. Day refers to. I can give you our fax, service by fax email address. One second, let me get that for you. lmstead@atg.wa.gov. And in terms of the dismissal, Your Honor, I don't know if it's appropriate to, I think I would defer to Ms. Day on this one and to Your Honor, but in terms of the dismissal, if that would be appropriate when the children are taken into custody, or if it would be appropriate in advance of that, I'll defer that to Your Honor.
Ms. Day, do you have any thought on that?
Well, my concern would be that if we dismiss today, then that leaves the children kind of in a precarious position should the mother appear and attempt to take legal custody and physical custody of the children. I don't believe the children would go with her. I don't believe that's a credible risk. That's not something that, you know, she's ever made a risk of that or even engaged in regular contact, but there is that small risk there. So I will defer that to the court to decide what they would like to do.
I understand that concern, but I think when a dependency matter is filed, that takes precedence over a minor guardianship action.
That is correct, Your Honor, but this was not, I did not ask for an immediate pickup. I just simply asked to have the matter noted and heard in open court. So the determination won't be made by the juvenile department until May 8th.
Okay.
I would agree with that, is that the simple filing of it creates the file, but not necessarily, that court has not grasped jurisdiction just yet. They will once it's heard.
All right. Well, I don't know that dismissal is appropriate then until there's jurisdiction in the dependency court. So with that, I should probably set this over past May 8th to consider a dismissal then.
I'm fine with May. Go ahead.
What was your suggestion?
Just May 9th, just the following May.
That's what I was going to do. So we'll put this over to May 9th. If the dependency court takes jurisdiction, then this matter will be dismissed at that point.
Perfect. Thank you, Your Honor. And I'll get these documents out to you, Ms. Olmsted.
Thank you, Ms. Day. And Ms. Day, have you filed a motion just by way of procedure for a motion for need for shelter care and cited it for the same day?
I did not do that because I didn't feel like that was super critical. I did file a motion for an order appointed attorney for the boys, but I did not go with shelter care just because of the complication of getting mother served. I felt like that was a little bit more daunting task than I was able to do in a short period of time. So hopefully I can accomplish this quickly.
Yeah, that would be great. That would provide the trigger for the court then to make a shelter care determination if there's a motion for the May 8th date.
Okay, I will go ahead and get that prepared then.
Okay, great. Thank you.
All right.
Thank
Is
you.
there anyone else who wants to be heard in this matter? Okay. All right, we'll put it over then on this docket to May 9th. It sounds like there's a separate hearing on May 8th, if anybody. All right, let's go to guardianship of Adeline Reeves. And at this point, there's been a motion to continue by Ms. Kennedy. I think everybody got her email on that. And so let's take that up. I think today is the day scheduled for a hearing as to whether this guardianship should be terminated. And so Ms. Kennedy, I'll let you lead off on that.
Well, I am not able to get into seek or talk with legal representation until Wednesday, tomorrow. I was not able to get in sooner. And so that is why I wanted to have a continuance, just so I'm able to speak with her. And I have been extremely busy at work. We've been down a couple housekeepers the last couple weeks, actually. And they also started training me for second head housekeepers. So I've had a couple extra hours. So I haven't really had time to put together my final declaration either. So, or submit that. I mean, I have it started. I just haven't been able to get it finished. And I wanted to go over my final declaration with the legal representation. So if there's any way we could possibly send it over maybe a week or two, that would be great.
All right, Ms. Winkles?
Yes, Your Honor. My client would like to go forward today. She actually asked people to appear on the record for live testimony. Additionally, we prepared a trial notebook with exhibits and a trial brief. We've continued this a number of times. If Your Honor will remember, the parenting plan action can't go forward unless this has been decided. The father and the mother are ready to essentially take this to the next level and deal with it in the family law court. Now, Mr. South will be able to explain the father's position more, and he might be okay with the continuance. But my client prepared. Now she has to call back everybody, and hopefully they'll attend the next time. But it does make it very difficult, and it costs the county money every time this happens.
Yeah, I also had recently went under emergency surgery, and that really put a loophole in things. And to be honest, I spaced that today was the hearing. So I have not been able to get really my ducks in, like my last few ducks in a row. And I have not been able to seek legal representation this whole time due to funds. But with a current side job that I'm doing, I now have access to free and deeply discounted legal services. And I would really like the opportunity to do that because I could not afford to get an attorney.
Okay, let me hear from Mr. South, okay?
Your Honor, excuse me, Your Honor. We don't really have a position. My client, unfortunately, isn't in a position that he could be here today unless he was able to show up. And so we would be in favor of the continuance. Also, I received Ms. Winkle's trial brief. I just saw it this morning. I really haven't had a chance to look at it yet. And it's probably 200 pages.
And I just received that last night.
I understand it was delivered to the court at 8:30 this morning, and I haven't had a chance to look at it.
Yeah, and essentially it's just, I'm going to have to authenticate all the exhibits anyway. So rather than do it like we used to do in court where I just show up and I hand people papers, I elected to give it to everybody in a clipped format, but I have to authenticate all the evidence anyway.
Ms. Smith, are you on this case?
I am, Your Honor. I'm the appointed GAL.
Do you have a position on the continuance?
I will defer to the court in regards to the continuance. I don't have a position either way. Ms. Winkles, I don't know that I've received the trial brief though.
And you won't, as the GAL, you're not a party to the case, so you only get what you're being questioned on as a witness, which would be your report. I can send it to you. It's just, I don't mind. I just didn't because I was just going to question you about your report itself.
No problem. I just wanted to make sure that I didn't get lost or that I didn't get lost on my end.
Would you like it? Because we can send it to you, but we probably have to deliver it to you. And I don't believe you're in the area.
I am in the area. It's fine.
Oh, you are?
Yeah. No worries.
Okay, we'll have it delivered. That not a problem at all.
Mr. South, are you able to make it next week?
Should be able to.
There have been a number of continuances in this case, but I don't remember that Ms. Kennedy has asked for one of them. I know the other parties have asked for continuances. It looks like Ms. Winkle's material has just been delivered to me. So I think based on what appears to be late filing, based on the indication by Ms. Kennedy that she's about to meet with counsel, and I'd like her to have that opportunity, and based on the fact that Mr. South hasn't been able to look through the materials yet either, I think there is good cause to continue. I'm going to continue this only 1 week.
Your Honor, I have a request. I have 8 hearings next Tuesday. Can we do a special set for a different day?
Special set is going to be 6 weeks from now, and I have to have you go to the universal trial setting. They'd have to find a spot for me. You don't want to do that.
No, I don't want to do that. So I will figure out something.
Either that or we go out 2 weeks.
2 weeks is judicial conference.
Oh, that's right. It won't. So that would be 3 weeks out. I don't want to go out that far. I really want to do this next week, and then
I'll make it work.
I have scheduled on the 19th the hearing for the parenting plan. So depending on what I do in this case, then that would allow me to address that. So let's put it out to April 18th then at 10:30.
And Your Honor, in the interest of saving time, instead of having all these people give live testimony, can we do their testimony on pleadings and have a date certain where those pleadings are put before the court? As in all the third parties, that the parties in this case can testify, but is there a way to allow third parties to testify via declaration and just say everybody's declaration from a third party is due on such date? I'm just trying to keep it down from 5 hours.
I know. I am not inclined to do that in terms of ordering it, because I think part of what I'm evaluating is the credibility of the witnesses. And if I just have declarations, I really have nothing to help me with the credibility.
Absolutely.
So I am, in this case, I think credibility is important for me to consider. So I'm not inclined to have the witnesses or order the witnesses and just do it by declaration. If any of them want to and cannot appear, want to put their testimony before me, that way they can do that. But I'm not going to order that.
Okay, thank you.
Okay, we have on the 18th, we have 6 matters. I'm not sure how long they're going to go. I'll take this case last, and I'll note to the judicial officers here, the judicial administration, that it may go after the noon hour. So if we get up to the noon hour, we'll take a break and then we'll continue after that if we need to do that. This case, my estimation is it will take several hours to go through the evidence and the witnesses.
And Your Honor, I may have to pop off shortly at the 1 o'clock hour for my 3 motions that I have on the family law 1 p.m. docket.
Well, then we could maybe start up again at 1:30 if we needed to.
That'd be perfect. Thank you.
So we'll address that next week then. Okay. All right. So we'll continue Adeline Reeves to next week, April 18th at 10:30. We'll see everybody back then. So
Thank you, Your Honor.
I want to just I looked through the file and I want to indicate a few things to get some feedback, I guess. I think this was before me last year for an emergency guardian for somebody named Heather Hayes. And I did grant that. That emergency guardian has now gone past the 120 days. So that probably doesn't exist. And now we're here on a full guardianship with the current person, Gina Kuanoni. And I guess I'm wondering, what's the relationship of Heather Hayes to this case? And
she's my daughter.
Oh, she's your daughter. Okay.
Yes. Yes.
Okay. And so your daughter is now not. What's her involvement? I guess I should just ask you that.
Well, she's still here. I mean, she lives with us.
Okay.
But when she missed her court date, at that point, Tina Day called me because I had already told her that I would be co-guardian with her because she needed to have a co-guardianship per Tina Day. And Heather did miss the court date. And so Tina called me that day and said, file your work or your paperwork right now, because you're going to take over. If not, things are going to be different. So I filed my paperwork that day.
Okay. And I'm sorry I didn't put this together, but then I appointed Ms. Farr in this matter, in the full matter. And so, Ms. Farr, what have you determined at this point, and where are you at in your investigation?
So the mother and father have not been served yet. So that's the biggest issue right now. And Heather will be moving out of Ms. Canoni's home soon. So she will not be caring for the child. Ms. Canoni will be taking over to care for the child on her own. And I have spoke with Tina a little bit about this case. And she filled me in on what some of the issues were from the first case, which had to do with Heather's background, which disqualified her. So Ms. Canoni, as far as I'm aware, doesn't have any disqualifications. And the child is safe and has been cared for by her in her home for a long period of time. Neither parent have been in this child's life, really. It's just a matter of getting the parents served and getting the proper paperwork filed. I did send Ms. Canoni several forms to get started on, one of which was the emergency petition, so that she could get emergency guardianship. I don't believe that anything has been filed yet. I didn't see anything in Odyssey this morning.
I have it. I'm sorry.
Go ahead.
I have it ready. It's all sitting here. I just wasn't sure. Anyway, I'll just listen. I'm sorry.
Okay, so we probably need to go over things again. Is that what you're saying?
Yeah, I have it
Okay.
ready. I just didn't get over there yesterday to file it, which was my intention. But I needed to talk to you more about serving them again. And I did fill out the service by mail for the father because he's in prison. So I've got that filled out, but
Well, so I'll give you a call after this hearing, but you should be able to serve him also without going through mail. You should be able to serve him through the prison.
okay. Okay.
And Ms. Farr can help you with that process.
Right.
All right, so Ms. Farr, it looks like we need to put this hearing out a ways, and perhaps before this comes up again, we'll hear the emergency minor guardianship. But how far out do you think we should put this hearing?
I'd say just to keep things going, probably, I would say a month. And Your Honor, if you believe that Tina should be appointed in this because she began this case, I'm happy to, I mean, that works for me too, whatever Your Honor decides.
I appreciate that. And you've done some work on it already. I think I'll go ahead and just leave you involved.
Okay.
I believe there was a report from Tina in the other case.
There is, and I have that too. So
why don't I just leave you involved? Sounds like you have a relationship with Ms. Kawani that should continue.
okay, we've been working together. So I would say let's if we can schedule it for a month out, just to keep things in the queue.
That would be May 9th at 10:30.
That works for me.
All right, so Ms. Kawani, please be back here on May 9th at 10:30, and I'll check in on the status of everything.
Okay. So now I have a question. When I file the emergency, is there a hearing before May 9th then on the emergency?
Yeah, what part of that will ask for an immediate emergency guardian, which should be granted.
Okay.
And then there needs to be hearing within 5 days of that appointment. And so there probably will be another hearing.
Okay, so Your Honor, I didn't give her the forms for the immediate, only for the emergency, because I thought we would be able to do that in one of these hearings.
Oh, okay. Well,
but the parents still have to be served. So I can send her the forms for the immediate.
why don't you do that? I think it makes sense that she have authority as soon as possible.
Okay.
To deal with, medical issues and things like that.
Okay, I will get in touch with her and get those over to her.
So yeah, let's do that. And then there won't be any, that'll take some pressure off getting the emergency heard right away.
Yes.
Okay.
Okay.
Okay, we'll see you back here then on May 9th, and I may see you before that. All right, last time we were here, the father, Mr. Lewis, had consented to the emergency guardianship. The mother, Monique Barnes, did not consent, and Ms. Day was appointed the court visitor. So let me hear from Ms. Day first, and then I think Ms. Barnes, I'll hear from you after that. Okay.
Thank you, Your Honor. I need just a little bit more time to complete my report. I've been able to do some work. I visited the child. I've met with the grandmother. I've had limited contact with mom. She has not returned or responded after our last court hearing. We had a brief conversation and I haven't heard from her since then. I was able to speak with the former CPS worker. And so I just need to have a little bit more time and hopefully an opportunity to meet and talk with mom. And then I should be able to have my report done. My estimation at this point would be maybe 2 to 3 weeks, depending on how quickly I can be in touch with mom and be able to move forward with that.
Okay. Thank you. Ms. Barnes, any response?
Yeah, she sent me the paperwork, I do believe, what, 7 days before this hearing. So seven days ago, I got you an email. She'd just now gotten a hold of me. That is not enough time to fill out the paperwork to even make the appointment. So there's no way I could have made an appointment with you, even if I did all the paperwork and turned it in and made an appointment. She's definitely right. We haven't had time to meet. I'm also thinking, what about a public defender? I was going to ask you about.
Okay.
And visitations. I was wondering if I was supposed to be able to ask for visitation. This is all new to me, so I haven't been to court in a long time.
All right, how long do you think you need to finish the paperwork and get a hold of Miss Day?
I have all of it printed out and about half of it filled out, so not very long.
Okay.
Couple days.
Okay. All right. Do you have any comment about putting this over 2 to 3 weeks?
I'm sorry, I didn't hear what you said.
Do you have any comment about putting this over 2 to 3 weeks?
I have to take a day off every time. This is just, she doesn't even have a job. So why in the heck didn't she get the paperwork filled out in 7 days? Come on, it's just, nothing is going to change with this situation. I've had Lance for a month and a half. He started school today. We've been to the doctor. We've been to the dentist. We are now playing t-ball. And this little boy has a life. And he is happy. He's getting better. When I first got him, he spits on you, kicks you, hits you. He's had no structure in his life whatsoever. My husband and I are breaking a stallion at this point, which we love him to death. I don't see either of his parents capable of being a parent. So I'm just going to go for pro custody.
Okay. Do you, Ms. Barnes would like to have some visitation with Lance. Do you, what do you feel about that at this point?
I'm not sure. You know, I just don't want to, his mental health right now, we're getting so much better. I would never want to keep a kid from their mom. I really wouldn't, Your Honor. I feel terrible about the situation, but if it's going to affect his mental health, you know what I mean? We can try something. I mean, I guess I have to give it a try to see how he's going to be affected by it.
And Your Honor, if I could input in there that at our last hearing on March 21st, when Mother appeared, she was granted phone visitations twice a week. And I don't know if those have occurred or not occurred.
No.
That would be very telling. If she did not make those calls, that would be very concerning to jump straight into personal visits. So I would say we need some consistency with phone calls. And Lance would need to be hopefully getting some counseling started very soon.
Well, we go to the doctor this afternoon. So I'm gonna see if he does need some counseling.
Okay. All right, Ms. Barnes has asked for an attorney, and under the statute, if she qualifies, then an attorney can be appointed for her. I'm going to check with an attorney named Kurt Anagnostou to see if he's willing to represent you. And if he is, then I'll make that appointment. I put this over from last time to today to address the issue of visitation. I was hoping to hear more from the guardian ad litem in terms of an interview and looking at Ms. Barnes. That did not occur. Also, it appears the phone visits that I allowed have not been happening. And I think it was up to Ms. Barnes to initiate those calls. So I'm not willing to increase any kind of visitation at this time. We'll leave the phone visits in place, and hopefully they can occur over the next few weeks until the work is done. Ms. Barnes, you wanted to say something, and I'm happy to hear from you.
Sorry, I was not sure. All I heard last time was that it was up to Gail whether I had the visitations or not. I wasn't sure if I had a restraining order, and I was too scared to call. I did talk to him twice because I was around the phone when he was on the phone, in one day, which was awesome. But I did not have any idea that I was supposed to call. I thought I would get in trouble for that. Just to put on the record.
Ms. Levitt, do you have any problem with Ms. Barnes calling for the purpose of talking to Lance?
No, I don't.
Okay. So again, I think I ordered 2 calls a week. I didn't specify when they would be. So you do have the ability to call Ms. Levitt. The only purpose of that call is to say, I want to talk to Lance. She'll put Lance on the phone. You can talk, you know, he's only 4. So, you know, as long as you can talk, you can, but that's probably not going to be more than 15 minutes, I would imagine. So each time.
Thank you.
All right, I'm going to put this over 3 weeks then. I can't do that. That's judicial comp. No, 3 weeks will be fine. So this will go over to May 2nd. To get to a resolution in this case, Ms. Barnes, it's important that you get the paperwork into Ms. Day and that you have a conversation with her. Okay. Okay, I see you got it. You told me you had it partially done. That's good. If you could get that in the next couple of days, that would be great. Okay. All right, we'll see her be back here on May 2nd by any chance.
Cody Stroud is deceased, Your Honor.
Okay. There we go. Okay. All right, Ms. Winkles, why don't you go ahead and tell me where we're at?
Yes, Your Honor. We're here on a presentation of the order. Ms. Boyd has received a copy of that order, I believe. Additionally, you wanted to talk about visitation in this hearing, so briefly just mention that. My clients don't feel it's appropriate at this time. We would ask that a guardian ad litem be appointed or a court visitor. Mom has had pretty much no contact with this child, who is now of such an age that the child would not know who mother was. The child is special needs, which puts an entirely new dimension into this. We'd ask that the court, and additionally, the child has had no medical care in a significant amount of time. So before we introduce any potential trauma to this child, we'd ask that a court visitor be appointed. That way, that person can work to see on reunification, if that's a necessity, or any of those things. I think it's very premature to just start up any type of visitation. We'd ask for a 30-day review of get a GAL appointed immediately, and some interim report after 30 days would be appropriate. Not trying to stop mom, just trying to protect this and the child has a very significant special need.
All right. Do we have an order in that case? Ms. Boyd, let me hear from Ms. Boyd on, I guess, first of all, there seemed to be some question as to whether you agreed to the emergency minor guardianship. Do you agree to that at this point?
I do agree to that, yes.
Okay. So
it has been a while now since I have seen her, and I agree with the impact that it could make on her as well. I'm not arguing that at all.
Okay. So then I will sign the order for the emergency minor guardianship. That will be effective for 60 days. And so that's as in the previous one today, that will be effective until June 10th. Let's deal
I believe, did we have May 23rd?
We did an order based on you ordering the emergency last time we were here, but I can change it and send you out a new one because it was 3 pages. It's probably lost somewhere in the courthouse anyway.
Okay, well, let's have the appointment as of today. That will put it out to June 10th, if you want to put that in. And I guess I do want to set a review just for the emergency minor guardianship. So that's going to be on June 6th at 10:30 to see if we need to extend it.
And can we get a court visitor such as?
I'm actually going to appoint a GAL in this matter. I think that makes more sense. And so, and just Ms. Boyd, so you know, we do this on a rotating basis. I just picked the next name on the list, and that is Mallory Smith. So I'll do an order appointing her as a guardian ad litem. A court visitor has a somewhat limited role to make sure that the procedures are followed and to give a preliminary review of the situation with the minor child. A guardian ad litem is a little more expanded, and they are required to advise the court as to what's in the best interest of the child. And at this point, I think that's what we need, and that's what I need going forward. So I'm going to appoint a guardian ad litem.
Can I get those court dates again? You said June 6th and June 10th, right?
Not June 10th, but
Nope.
just a moment and I'll give you that. June 10th is when the order that I entered today for the emergency minor guardianship expires.
Okay, so
June
you said it
6th.
before that. Okay.
Yeah, June 6th is the hearing date, so we can look at that before that
And that's at 10:30, correct?
at 10:30.
Okay.
But I think it makes sense. Go ahead.
I'm sorry. What about a lawyer or an attorney? Am I able to get a court appointed one?
You can, as the parent. I indicated I was going to appoint Mr. Anagnosti to a earlier case. I don't know if he's going to be able to be appointed in your case, so I don't know who that will be at this point. But
So
if you wanted
my next step, do I call?
No, leave it to me. I need to contact one of the possible attorneys and see if they'll take the case.
Okay.
Okay, so to check in on the appointment of counsel and also to check in on the status of the investigation by Ms. Smith, I think we need to come in on May 9th. So there's two hearing dates then coming up, one on May 9th at 10:30 and then one on June 6th at 10. All right, any other questions?
No, Your Honor.
Okay, Ms. Boyd, my judicial assistant will be in touch with you once we determine who the attorney will be that will appoint. Okay.
Okay, perfect. Thank you.
Thank you, Your Honor.
All right. Thank you all.